Banking and Trust by Moving Titles in Commerce, featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Welcome, everyone, to this Tuesday, July 6, 2010 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology, and we'll do the disclaimer next. Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or implored for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein reference, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and our show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
Q&A session started.
So again, I'd like to welcome everybody to this Tuesday, July 6, 2000 edition of NTT. We're going to go directly to the Q&A again tonight, so press star 6, star 1 to get into the queue line, raise your hand. Press star 6, star 1. We'll go right into the Q&A. So if anybody has any questions or...
Hello?
You're unmuted.
Hey. Found a really interesting book today called Trustees in the... Oh, no, it's not. That is the chapter. It's called Trustees in the Commercial Context. But the book is called The Private Trustee in Victorian England. Now,
date on it?
On the book itself?
Yeah, copyright.
Let me see. 2002.
2002, okay.
And what it talks about is back in the day, when people were living off these trusts that they were setting up, and it was all on the onus of the trustee to, bring the funds to the beneficiary. And what was happening was that as the time was going by, commerce was becoming more the done thing. So these trustees who'd been, going to be farmland or some tangible thing that were now given instruments to use in commerce, and basically the trustees had to rush themselves into commerce and understand commercial paper and everything. So it's just setting the tone really for things that we want to do with the res. So my question kind of is, have you heard the term consol? C-O-N-S-O-L?
Yeah.
Okay. Because I looked it up on the internet and it was going to consolidated annuities.
I think the console I was thinking of was the a person is giving advice or counseling to another.
S-U-L. This is C-O-N-S-O-L.
S-O-L?
Yeah.
Well, maybe we're all S-O-L on that one. So.
Sorry?
Maybe we're all S-O-L on that one.
S-O-L. What does S-O-L mean? Okay.
Down the line.
So I looked up, I found this website, anyway, it's called Immediate Annuities, so people can have a look. And it's got some annuity documents from a long time ago. But basically, it's kind of setting the interest rates. So, for example, this one is £4% annuity. Now, I think that the cent originally, because it's got per cent, and then the C is a capital C, and then it's got a full stop. So per cent must be like per century annuity or something like that. So it says,
one, tax 8 is annuity bond under bond.
Yeah, the bonds, like, yeah.
It gives number 3, which is corporations, and it says to unite 2 or more corporations or other organizations to create a new corporation or other organization.
Well, what the book was going on to say, and it kind of pauses, unfortunately. It's got a few pages missing. But what it says is that a lot of the trustees were running to the courts of equity, or the courts of chancery, sorry, because of this sort of like commercial world that they were being pushed into by the beneficiaries. And it describes the beneficiaries as being mercenary, very mercenary in their actions. I think it was because of the flurry of the time of like the economic upturn with the Industrial Revolution and everything. So there was lots of money around, and then there was something of a collapse, maybe after the Battle of Waterloo. So these trustees were holding these indentures with instructions to create money for the beneficiaries who were living off these annuities for the rest of their life. But as I say, the book cuts off. Anyway, the way it describes it is received this day, 28th of August, 1749, by Rob Hadsley, Esquire, the sum of £318. So the dealing in sums being the consideration for £300 interest or share in the capital, which is equity, or joint stock, erected by an Act of Parliament in the 20th year of the reign of His Majesty King George II. Now, I don't know if you guys can do it in America, but we can draw up private statutes in England. I don't know if you can do that.
Draw up private statutes?
We can write our own private bills, yeah.
We should be able to here, but that's been frowned on because they've kind of taken that right away from us because that right's been put into trust. We can't do that in the democracy, in the United States. We should be able to do that under the Republic, though.
Yeah, because these are private statutory instruments, like they're not public statutes. I think it's probably going to be something to do with the law of a trust, you know, maybe to keep the state out of the trust. But the law is recognised by the state as a bolster or leverage.
Yeah, well, where we really got off point is when we started going into the trust and they started going into the commerce end and they started doing and they went into the fee offment tenant relationship or the renter, which is, I think, is totally off from what the trust really should be. But then we start creating these negotiable debt instruments, and that's our problem. We need to be staying away from negotiable debt instruments.
Yep.
Not to be creating these negotiable instruments anymore. And realize that I don't really have to. Because if I just do merger of titles, extinguishment of debt, it's going to achieve the same effect. And it'll be extinguishing the debt. It won't be creating the debt. And I think a lot of you out there, including the trust ambassadors, are not grasping that. Sounds very tempting to go out there and create all this debt, which you can do that very easily. But you've got to realize what that's doing. You're contributing to the problem that you're trying to fix. A runaway society that's hooked on debt. The debt is a drug. And you want to go back into your drug, creating your negotiable debt instruments, thinking that, well, it may fix my solution and fix the particular now problem, but in the long run, you pulled the rug out from under yourself. So I'd be very cautious about creating debt just to solve an immediate problem, but hang yourself in the long run. So all these books that are floating around here, they all sound good. We better take them with a grain of sand or a grain of salt. We better keep things pure under NTT and extinguishment of debt and stick with the goal instead of getting sidetracked, because it's too easy to get sidetracked. So go ahead, Pete.
Yeah, I'm noticing how the flow of the time, changes, and this book, it's let me just find the name of it. It's called The Private Trustee in Victorian England. So it just, from time, like it seems to be the 1820s to 1860s where the commerce has really hit England, and the trustees have now become like professional brokers. And whereas they were using the substance of things, like the note would be a substance, like as I say, a farm or some animals, and people would receive the fruits thereof, which in turn is going to perpetuate, because the farm will always produce, the animals will always produce, and there's your equity. But the debt instruments don't produce anything.
Except more debt.
Except more debt, yeah. Yeah, I was just wanting to brush up, get everyone up to speed where I was at with my study. And in the book I'm reading, the Institute's book, it talks about if you want to know about trusts, this is one point I wanted to ask you on actually. If you want to know about trusts, you have to learn about conveyancing.
Well, that'd be moving titles.
Exactly. That was my question. Is that what moving titles is? Is it the conveyancing of titles?
Yeah.
Yeah. Yeah. Cool. Awesome. That's me then.
Okay.
Thanks a lot.
Okay, next caller, you're unmuted. 434, you're unmuted.
Christian, this is Floyd.
Hi, Floyd.
I have a question about the private trust that we set up with the bank. You did say it was a private trust. I believe I heard you say that, right?
We could set up either a private or a public trust.
A private or a public? It can be either one?
Yeah, it could be either one.
Okay, I don't understand. I thought we were keeping everything in the private. And I mean, as far as our business is in a private, and we're only interfacing with the public through our LLC, right?
Right. Yeah, but I was going to say that we do have the option to create both.
We have the option to create both.
Yeah.
Oh. Well, the reason I'm asking that question is because I've been talking to the banks about the 78 number that Mike had said something about on a call, and none of them know anything about it. Is that a private number, or what is that?
I believe that's a number. They don't know anything about that?
No, none of them know anything about it. Even their trust departments don't know.
78 or 98. Let's see. I guess there's two series of numbers there, but they come from the IRS.
Is that where we should check for them? Maybe the IRS could tell us.
Yeah, but I'm really surprised that the banks don't know anything about those.
Well, I've talked to 3 banks now, and none of them know anything about anything like that. In fact, and it's not the tellers that I'm talking to.
Oh, well.
So how high up do you have to go in the bank before you find the answer?
That you'll have to keep trying upstairs, keep going up one, see where until you finally don't cover who's got the knowledge on that. Okay,
well, because I'm assuming that's a number that is assigned. Well, if that number is assigned by the IRS, how can that be a private number?
Yeah, well, that's one of for what we were doing, that LLC that we're going to have as trustee, that's going to be over a trust. That trust to be a public trust, because we really want that to be recognizable in the public, because that's the one that the interest on the trade is going to be generated, and that's where that interest is going to go, in that public trust.
Okay. Well, then we can set up a private trust actually behind that public trust then, right?
Yes, because that reformation, I want to say reformation, the termination of the strawman trust and then forming a new trust on the private side, and the remainder from the terminated strawman account be put into the new private trust. It's on the private side.
Okay, you cut out on the. Could you repeat that again?
It stays on the private side, that new trust that was created, and the remainder from the old strawman account is put into that new private trust.
Okay, but now that private trust, is that a private trust in the public, or is that a private?
No.
That's a private trust in the private then?
Yeah, this one's just private.
Okay, just private. Okay, all right. That's what I wanted to find out, because I was a little confused on some of the conversation that I'd been picking up off the tapes.
Yeah. So the broker is going to generate the interest from the private side assets that are locked up in trust.
Okay, I can understand that.
He's going to do the trade, he's going to generate the interest, and then he's going to deposit the interest on the public side trust.
Okay, all right, I see that.
The broker is going to be doing the actual, well, nothing changes from one side to the other. Nothing crosses over.
Right,
that
okay.
Private asset is locked up and held as a trade, and then that was derived on that that private trust is then the interest is put into that public side. So the broker is the agent that does the transaction and creates the interest.
Okay.
And you don't do it.
Okay. Okay. All right. Well, I'm setting up some of my paperwork right now so that I'm pulling everything out of general deposit and putting it into special deposit, and I'm holding it in the private right now until I get ready to transfer into a special deposit. So
we should have these trusts already set up on the public side.
Well, that's what I'm working on right now. Yeah.
Okay. You need an interface created before you cut yourself off and can't get back in again.
Right. Yeah, and that's why I'm trying to find out about this 78 number, because I thought it was something that well, according to what I heard Mike say, was that we had to have that, or at least he has that, and I was trying to find it, and I just can't find it. So I didn't know if he had set up something in the public, or if that was totally private and you couldn't find it because it was private. So.
No. Usually, I think if it comes usually from the IRS, like something like that, that's readily accessible, then that's going to be a public.
Yeah, right. That's what I was thinking. Yeah. Okay. Well, that was my question. So if I run into
I'm going to the assumption that everything is really public unless I can prove that it's private otherwise.
Okay. Yeah. Well, it's kind of like the Constitution, you know. I mean, it's like the Bill of Rights, or well, actually, it's like the Constitution. Everything that doesn't belong to the government belongs to us. I mean, as far as rights, you know, everything else is ours. So, anyway, I don't know if that's a good analogy or not, but that's kind of the way I kind of see it, anyway.
Check your Skype.
I haven't checked Skype today. I've been so busy. I just got in about 20 minutes ago and got something to eat and got on the call, and I was late getting on the call, so I haven't had a chance to do much of anything. But I'll check it tonight before I go to bed.
Yeah, you going to stay up for the whole show, because I was going to talk to you afterwards. So.
Yeah, I was going to stay on for the whole show. I was going to listen, even though I might not get back on again.
I'll make it a point to get a hold of you then after the show.
Oh, all right. I'll stay up and wait for you then. Okay. Very good, Christian. Thanks.
All right. Might be an early show because nobody's on the queue line. So, anybody have a question? Press *6, *8. Or wait a minute. *1. Excuse me. *6, *1 to raise your hand. 714, you're unmuted.
Hey, Christian. How you doing? This is Dan from Southern California.
Hi, Dan.
Yeah.
Does it ever rain in Southern California?
Well, surprisingly, the rest of the country is experiencing a heat wave, and it's, July 6th, and we're over here by the coast, and we've been enshrouded in very cold coastal fog the better part of the day. It's been about 60.
Well, at least it's not acid rain from a bunch of oil spills.
Yeah, I know. Man, people probably need to get out of there. That thing's going to get really bad. The coastal currents are going to push that stuff all around the globe eventually. This thing's a complete catastrophic event. Just the methane. There's thorium and tons of radiation coming out of that crap. That's young oil. But either way, are you near any of that? Are you on the coast in Florida?
Yeah, I'm on the
Atlantic side.
On the Atlantic side, yeah.
Wow, what a mess. But at any rate, on page 41 of Gilbert's, where it says merger of title, where sole trustee is also sole beneficiary. I don't know, maybe I just forgot over the last several months, but it says where the trustee and the beneficiary are or become one and the same person, the legal and equitable titles merge, defeating the trust and creating a fee simple absolute in the trustee beneficiary, who thus holds outright and free of trust. And that's also in the third restatement, section 69. Now, in that statement, does the payment is made, right, when you have a merger, and if you merge it, does it depend on who you merge it in? Like if I appoint someone a trustee and then assign them beneficial title, now when the trust terminates at that point, does that person hold it in fee simple absolute?
Yeah, they do.
You know what I'm saying?
He has the whole ball of wax, but he's also got a duty according to the indenture or the trust purpose.
Okay, and that's depending on what my purpose is, right?
Yeah, so the purpose was by the grantor that the distribution of trust res should be given to the beneficiary upon termination of the trust. Then when he gets both titles and the trust terminates, his responsibility, his duty is to wind up the trust, is to do a disbursement to the beneficiary.
Okay. Because when I read that again, I'm reading Gilbert's all over again, and when I read that for the second time, I sort of went, wait a minute. If I merge these two, invest both titles into one entity, I don't want them to end up with whatever the trust res is, because I've created a fee simple absolute in whoever that entity was. So I was just checking to see, make sure that I don't merge titles into somebody that I shouldn't have, Because also in Black's Law, if you look at fee simple absolute, it gives a pretty vague. It doesn't really give you a clear definition on it. It almost tries to mislead you into thinking a fee simple absolute is basically the same thing as a fee simple, but obviously when you merge titles,
it's got to do with the possessory title, but then it's like the beneficiary, he's the one that's got the actual ownership rights.
Right. So let's say in a mortgage thing scenario, the trustee was the title company, and they're holding bare legal title, and we merge the equitable title, the beneficial title, into that entity, and then now you've created a fee simple absolute, terminated the trust, but now our indenture states to that trustee or gives directions on how we want the trust res distributed at that point. Is that correct?
Yeah.
Okay.
Like they're misusing the trust to what they want, because we haven't said otherwise. And that could be used to our advantage once we learn what's going on and how they're doing it. And we can use that to work it against them. The fact that they don't use the trust the way it's, I think, godly meant, but then it's the fact that no party in the trust needs to know that their trust has been formed or being operated. I think that's the big deception.
Right. Well, I was going back over some of these securitizations of the mortgages and stuff, and in my particular case, the quote-unquote lender is keeping the identity of the beneficiary secret, and nobody wants to identify who that person is or what that entity is. And also in Gilbert's, if a beneficiary doesn't exist at all, which I'm thinking that might be the case, that's why these banks are playing cat and mouse as far as who the beneficiary is, because they're really.
That can't be the case. A beneficiary always has to exist. or it has to be identified within some specific time, or else there's no trust.
Well, that's what I'm saying. That's why I'm thinking a lot of these securitized asset trusts or whatever are bogus, because I don't think that there is a beneficiary. And
there might not be. Maybe it's just an agency relationship or some other type of relationship. But that doesn't mean I couldn't turn it into a trust.
Right. Like I guess what I'm saying is if whether I turn it into a trust or not, if they're operating, if they're trying to make it look like they're operating a valid trust and they're not, then the trust property reverts back to the grantor, right? At that point.
Yeah, he could force it back. Yeah. But all these securitization trusts are just dealing with one title, not both titles. Because usually it's just the legal title that they're putting into trust, and then they're splitting that up in trust into legal title and beneficial title again. But it's just based on, what title is it based on? It's based on the legal title. It's not based on a perfect title, and it's not based on two titles held separately, but yet the two titles are put for the trust res.
Okay.
Because if they did, they would have merged the titles, and that would have terminated the trust right from there. So they didn't do that. So it's like a P game. You're using the trust, use it as a Kansas City shuffle or the P game shuffle, and the beneficial title is never leaving the hands of the state. And we're playing this hot potato legal title trust thing, statutory trust thing with this legal title. And we're putting it into a trust, and we're securitizing, and we're splitting that legal title into another legal title and a beneficial interest again. But the beneficial interest and the legal title that was split into is based on just a legal title, not a perfect title. A legal title with a beneficial interest. But if they did that, that would have merged the titles and terminated that trust to begin with, so they couldn't do that.
So the equitable title has always remained with the county?
Yes. You look up privity of estate in Black's Law. It says that's a success. There was no perfect title. Well, there was a perfect title to start out with, but then after the first registration in the county with the formation of the trust, from then on it became a successive trust. And all we did was succeed in passing legal title hand to hand, and we went from the county never having to give up the beneficial title. All they did was the other title just got switched around.
So transaction after transaction, year after year, on say a 40-year-old home, the county has kept that beneficial title every single time that house has changed hands?
Yes, right.
Wow.
It's never left.
Okay.
It's been a successive trust.
Well, hell, we got quite a bone to pick with the county then at that point, as far as doing a merger on them, huh?
Well, I don't know. We created all that. I mean, it's like, yeah, I know we got a bone to pick, but really I was the first one that had dropped the ball, and they picked up the ball because I dropped it and they ran with it. So I really can't blame them for running with the ball. I can blame myself for me dropping it. Now, if they made an incorrect touchdown and didn't go by the rules when they were running the pass with the ball, then that's a different story then.
Right. But now, they have beneficial title of, we're saying the title, the perfect title to the home, right? Which would be.
We don't have perfect title. Perfect title is both titles merged, and then you don't have a trust.
Okay, so you could either take the legal title from the title company and merge it into the county, or you can merge the equitable title from the county.
If you merge the titles and you terminate the trust, what you've done is you've perfected the title. You've made a perfect title again.
Now
you've an allodial title.
Okay. could you also say that's still a fee simple absolute? Is that the same thing as a allodial title?
I'm not quite sure whether or not, because that comes back into the tenancy laws, and that's what I don't like about the trust ever since it came about from the statute of uses, because we really went into feudal times still today, where we still are tenants. We're nothing more than renters.
That's alive and well. That's definitely obvious. But on the because I was just because in Gilbert's it uses the exact wording, which creates a fee simple absolute when we merge titles.
Yeah, kind of a misnomer term. It's a misleading term, really. It
right.
makes you
That's what I figured.
your owner, but you're not.
Well, because that's the in all these statutory trust books, that's the nerve, right? That's the main thing right there is merger, and they always tap dance around those explanations.
Yeah, they don't want
you to really
merger, because if you did the merger, you perfected the title again, and they don't want that.
Right. Well, even in all these old equity jurisprudence books, I dug up in the law library. You get to the merger section, and what do you know? All of a sudden, the language gets really vague and convoluted. It doesn't really
I wonder why.
anything.
Yeah.
Right. And,
I'd like to point out on that section that you were reading, that section 159 on page 41, that came out of the restatement of the third.
Right.
Now,
section
maybe
69.
the restatement of the second might be different. Because what they're doing is they're changing the rules as they go along from, the second to the third, and they're making it more geared towards commerce, for speeding up commerce.
Right. The modern view, right?
Yeah. Well, that's what I like to do is put in my trust indenture that it's in 1776 AD law form.
Right. Now
all
on
the unalienable rights, and we go back to the old trust law of when this country was founded.
Right. Makes sense to me. Going back to title, now when the county's holding beneficial title, we know that, but now title to what? Because now my deed of trust and my note, those as well have legal and beneficial title, which I can certainly claim because those are my signatures on those documents. So now are you?
It's the invisible title, which is the right, and that right the beneficiary is holding.
Now, in my paper, on my negotiable instruments, my debt instruments, which is my note, my security agreement.
It's an invisible title that the beneficiary is holding. It's a right.
Okay.
It's not like a piece of paper that you can say, here it is.
Okay.
It's an invisible title. It reflects a right. It is the right that the beneficiary has in the trustee because the trustee has a duty to the beneficiary.
Okay.
That's
the
title.
The title company.
That's the beneficial title.
Right, but the trustee, like the title company, has the duty to the county because the county is holding the usufruct or beneficial
right.
interest. And
the trustee owes a fee to the county for the use of the res trust property.
Right, and that trust property is separate from my trust property, which is my deed of trust or my note or whatever I've signed to.
The county trust is different from the note trust.
Gotcha. Okay. So the note trust, we can merge that no problem at any time into whoever we want, right? Basically, the servicer or MERS or whoever you want to pick on, you can merge legal and equitable title for our notes into whatever entity we choose.
Right.
For the county, we need to merge legal title to the property back over to the county or whoever.
Yeah, you're doing basically the same thing as you're doing on the note, but then you have to do it a little bit different way because you got to look at it the way that it was incurred. You are not the grantor on the county. The grantor was the previous seller.
Okay, right.
You're the grantee or the trustee on this trust. You never were grantor.
Okay.
But you got to get in a grantor position. If you got, now how would you do that? Because you can't merge titles unless you're, say, a beneficiary or you're, got some way of, say, as grantor to do that.
Well, if I'm trustee in that relationship, then let me see.
How are you going to get in grantor position?
How am I going to get grantor position? Well, if I'm trustee, then I could merge legal title over to the county and terminate the trust at that point. And in my indenture, say that when the trust terminates, I become holder of perfect title, which would then allow me to grant that at a later time, right?
Yeah, but see, let's see what happens. Let's take that scenario you just mentioned right there. So
okay.
If you are the trustee, and you merged your trustee beneficiary, which is the county. Now you just completed the trust indenture because all trusts have to be dispersed, and the disbursement goes to the beneficiary. So that's the county. So now you just gave them the whole thing.
Okay. Now, what if? Let me see. What if my indenture named a different beneficiary or a co-beneficiary?
Where are you getting your indenture from? You're trustee on this, and an indenture has to be written by a grantor.
Right.
Are you
okay.
grantor? You're not grantor on this.
Right.
So you can't write an indenture because the indenture has already been written, and it's been written by the previous grantor, who was the seller of the property.
Okay. I'm trying to work this out in my mind, how I would take control, grantor position.
Okay, I just really told you, if you caught it.
What's that?
I just really told you, if you caught it.
Oh, okay. Well, let me see.
What was the last thing I said?
What was the last thing you said?
The previous seller was the grantor.
Oh,
and he wrote
okay.
the indenture.
Okay.
How do you become grantor?
If the previous seller wrote the indenture.
How did he write the indenture? Why did he write the indenture, the previous seller?
Well, what if the previous seller didn't write an indenture?
Well, yeah, he did.
Oh, his deed of trust?
Yeah, he wrote a deed of trust, yes, which specified you as trustee on that property.
Right. I was the grantee when I bought it from the previous guy.
Yes.
Okay.
So who gets to write the indenture?
The grantor.
The grantor. How do you become grantor?
That's I'm not seeing it. I'm not getting
You sell the property.
Oh, okay.
The seller is the grantor. The one who buys it is the trustee. So if you want to be grantor, sell the property. Sell it into a new trust.
Sell it into a trust. Okay. I see what you're saying. Okay. Now, would that go back to an LLC or sell it into a private trust?
Well, now, if you're going to get rid of it, the county say, then you're going to have to do some other things there.
Right. Is that something you're going to get into in the somewhere in the near future here?
You got some problems with the county because the county's probably taken this property and locked it up in the trust, and they're using it as an asset to generate CAFR funds from, and bonds and different things, or whatever it's drawn against. But when you unlock this principal from them, then they got a problem, because you now created all these floating bonds out there that don't have any source connection.
Right.
So you got to write some kind of an instrument to take the place of the trust residue, pull them out of there, so that those bonds can be connected again to some kind of source. And it would have to be an equal amount probably to the value of the property. And then, I don't know, who knows whatever else expenses they've got attached to it. So you might have to have maybe another instrument to pay all the obligations, or maybe a merger document to take care of those by merger.
Okay. Now, if you were to, let's say, use NTT on the banks and merge your debt instrument titles and terminate the trust in that regard, but you still got the county to deal with, because in my case that's another trust. I haven't paid mortgage, I haven't paid property tax on the property I'm in for quite some time. It's only a matter of time before the county exercises its beneficial interest and tries to collect on all that. So that's, you'd have to come back around and settle up with them as well.
Yeah, you have to take care of that public debt, and as well as the private side of that public side debt, which would be all these other bonds that may be connected to the property. They use that as an asset to fund all this other stuff.
Right. And then to sell the property into another trust. Now, would that be like a full-blown legitimate sale, or would that be kind of a symbolic, kind of a nominal sale? Like something.
Well, that might be just maybe a private trust, maybe. I don't know. I have to think about that to see whether or not if that might be the best route to go.
So maybe like
that would be pulling it completely out of the county's rolls then.
Well, could it be just conveyed into a private trust and then create a grant deed on that in the county?
Yeah, but once you can't put it in the county, because if you put it in the county, then you're making it public again.
Oh, right, okay. So maybe you'd have to create the documents and then come into a court of equity to handle the county's beneficial interest, right?
Yeah, you'd have to somewhere make some kind of substitution for what you took out, substitute something back in, or else terminate and extinguish it all.
Well, I mean, I wouldn't lose any sleep over the county not being able to float a municipal bond or a CAFR bond because I removed one of their supposed assets.
Yeah. Now here's the thing. Problem we've been kicking around also with that. We don't know when the maturity date, how that's going to affect on these bonds. We don't know whether or not we can extinguish these, say, without any havoc of creating a wave into the system, so to speak, by terminating these bonds before their maturity date.
Right. Well, if they would be honest and straightforward with us and give us an accounting and come clean on all this stuff, then maybe we could be reasonable and work with these guys and actually issue them assets instead of.
Yeah, that could be workable if you'd find some knowledgeable person to be willing to talk to you. But you'd probably have to get them on a confidence agreement that everything they said would be, strictly relied on as being private.
Right.
And then I don't know. You just have to try and shop around to. This is like changing the attitude of a stone. They completely forgot. They don't have any mind at all.
Right. That's interesting. It sounds like quite a bit more work to do on the trust side. Yeah,
everybody thinks that this is, hey, let's just go out and do it. No, I think you better think before you jump, or else you got yourself instead of a parachute, you got yourself an umbrella.
Right. Well, I mean, we can understand a general. I mean, there's materials to learn from to grasp a general knowledge of trust, but to really get into the nitty gritty and know how to maneuver your way around and negotiate things like with cities and bonds and all that stuff. You know, there's no public sources out there to learn that kind of knowledge. Not that I can tell.
Well, I don't think it's really kept private. I mean, they have it hidden right. It's there out there about the CAFR funds and all this stuff. Where are they getting all these funds from? Well, they're generated off the trust assets that you put into the county.
Right.
So they've got all these assets that they are utilizing in some way. So they're writing bonds and debentures against them or whatever, you know, and they're taking good care of the assets. They're segregating and keeping them in trust, you know, just according to the indentures, and then they're investing them and waiting for us to pick up the funds or do something with it, and we're not. We're abandoning them.
Yeah, well, they're trying to make us believe that the only way we can ever repay anything is for them to harness our energy and capture our labor.
Now, it's really not a true abandonment, because true abandonment means you have to have an intent to abandon it. But you always got to remember that's debatable because it depends on what side you're on. It's relative to, from your point of view, whether it's coming from the private side, which is where you got to have sentier, and you couldn't have a true abandonment without knowledge and intent. But on the public side, it's different. It's flip-flop. They can manifest a record which you never knew anything about. In other words, you didn't have intent, but they go by the record, which was the manifestation of your intent, even though you didn't know or not. So one side you have intent here, and the other side you don't.
But then on the other side, but on the side where you didn't have knowledge, once you come into that knowledge, then the laws say that through mistake or fraud or by accident, you have the right to turn that around.
Yes, on the private, yes.
It's an uphill battle.
But the public,
even when
exactly.
I get the feeling that even when we get to the point where our documents say what they need to say and prove what they need to prove, it's still not going to let you get through that door very easily.
Yes, but that doesn't mean we can't do it, though. You know, it's just
no. That certainly doesn't mean we can't do it, but it's.
I think that if you look through it with trust eyes and all the facts that we've gathered under the debtor-creditor, now it becomes more clear and it comes together under the trust eyes.
Right. Well, what's unfair even in court is with these banks and these courts, how they're working in tandem. You know, they're using the law of trust to keep all their banking information confidential, but then they're also using the debtor-creditor world to beat you up as well. So they're kind of using both worlds.
Well, we're choosing the debtor-creditor world to beat us up because that's the world that we chose.
That's true. That's true. But
we made all the contracts.
Right.
We made all the colorable debtor-creditor contracts. And we didn't make any expression of any trust, although they knew it was trust. But they weren't the ones claiming it was a trust, so they don't have to prove the trust. And we didn't know. So we're not claiming trust either. So we don't have to prove trust either.
Right.
So you see, it's a very deceptive realm, but that's the way it's operating. And now that I know that it operates that way, now the game is up, and now I know how to play the game.
Right. Cool. Well, I guess all we can do is just keep chugging along.
Yeah, and not lose sight of NTT and keep it pure.
Right. Well, I'm all for that.
Yeah, how we're watering it down is we're commingling debtor-creditor with it.
Right.
Because a lot of us don't have the discernment to pick out the debtor creditor and to know that that's separate and we're mixing it in.
Right. Yeah, well, I'll keep calling in and learning as much as I can. But thanks for all your time. That's all I had.
Well, those were some excellent questions. Thanks.
Great. Thank you. Take care.
Okay, next caller. You're unmuted. 239, Florida. You're unmuted.
Hello, Chris.
Hello. Yes, who's this?
This is Richard from North Carolina.
North Carolina. Okay. Go ahead, Richard.
How you doing?
Not bad.
I've got a situation. I had a civil summons on a credit card, and I accepted the summons, signed it as grantor, created the UCC 1 and 3, presented it, and appointed the judge, co-trustee, and the attorney that was suing me, co-trustee. Notary presented it back to them in the case, in the private. And I had also submitted a notice, I'm just looking through my paperwork, for cancellation of the case. I had the grounds in there. So I went into and he rejected that. And then I filed a motion to compel. Went back and went over the motion to compel, or the plaintiff's attorney asked the court to pass judgment on the things I'd asked. And of course he disallowed everything that would have shown that the credit card company was not the creditor that I was. So he disallowed all that. Now, I've got another hearing coming up. But what he did, and I received it later where I had appointed him co-trustee, he said that it was legally impossible for him to be co-trustee.
And that was who said that?
Huh?
Who was that said that?
The judge. That it was legally impossible for him to be co-trustee.
So he was disclaiming.
Well, yeah, and I had 14 days on there for him to decline, and he did not respond in that time. It had been about 30 days since I had sent it. So do you have any suggestions of what I might do in that? Because I've got another hearing on the 9th of August.
Yeah, what was your cause of action going into this?
Pardon? What
was your cause of action going into this?
Of course, it was 2 credit cards, American Express credit cards.
No, what was your cause of action going into this?
Whenever I requested, I'm not sure I follow you.
Well, they come at you with a cause of action. What did you come back at them with as a cause of action? That's why you got hammered.
Not sure.
That's why you got hammered.
Uh-huh. Well,
Did you claim equity?
Did I claim equity? Yes.
How? How did you claim equity?
With the UCC filing?
No.
Well, whenever I accepted the summons and signed it, did I not claim equity on the summons?
No, there's certain equitable switches that need to be in a pleading that invokes equity. And we've been talking about that over the last, at least the last month or 6 weeks or so, when we're going over the equity and corpus juris secundum. And in a pleading, you must invoke equity to get equity. And one of the main things is that there is no adequate remedy at law.
Uh-huh.
So if I claim trust, if I say this is a trust, and my cause of action would have been, say, breach of trust, and I put in there that this was a suit in equity, and my cause of action was breach in trust, and that was my counterclaim is in equity, trust is in equity, and I'm also invoking equity by saying it's a suit in equity. Put that maxim in there that invokes equity also, which was really that, let's see, where's it at? If there is no remedy at law, equity should act. That's a maximum equity, which is based off of that principle, that equitable principle, that there is no adequate remedy at law, then equity is to take place. So there's.
Well, didn't he breach the trust?
No, he just recontracted over you because he said that, legally he couldn't do that. And what did you say in the meantime? Did you haul it back to that? Well, you're sitting there holding trust res. You didn't do any disclaimers officially according to trust law, but yet, you know, I think where you maybe messed up was you didn't really claim trust and prove trust to start out with. What was it that you put into the court on the public side that expressed any kind of cause of action under a trust?
I had a motion. I'm trying to see. I filed a protective order in the public. No.
Did you have a hearing for it?
No, he wouldn't. I asked him
Why
to have
was
a hearing.
What was his reason on not having a hearing then?
What he said, whenever I asked him, he said, well, there wasn't anybody. There was no people in the courtroom. He said, there's nobody in here. Let's do it here. And he sat up there with his robe on, and he wouldn't. That's what he said. He was just tricking me. He knew I was a novice.
Yeah. Uh-huh.
And he was playing me for it. So he said, well, there's nobody here. We can just do it here. And then I brought it up, and he denied it. Bam. He got me.
Yeah. So what was your motion called? For a protective order?
Yes.
Yeah, I don't think there was enough in there to invoke the equity, and he was out there to test it to see whether or not you knew it.
Yeah, I mean, I knew he was doing that.
Yeah.
And I obviously, I mean, he got me, but I didn't know whether I had, because he still, you know, I'm going back in there one more.
By in chambers?
Pardon?
Did you send him any private documents in chambers?
I sent them to him in chamber. I had the notary.
What did you send him in chambers?
I sent him the motion to a notice. I sent him a notice filing a trust action and filing a statement of accounts. And it said this is a private communication notice to principals, notice to agent.
Okay, let's assume that you were putting in SOI evidence and the SOI evidence was correct, which is another issue altogether.
Right.
But let's assume that that was SOI material that you put in as substantial facts to substantiate your claim for trust.
Uh-huh.
An SOI has to be supporting an NOI, and the NOI has to be on the public side, and the SOI has to be on the private side. So if you didn't have a notice of interest, which was my claim for trust, on the public side, then there's no equitable action at all. And then your SOI that you put in chambers is unsupported with an NOI, and it's worthless. So you got to have an NOI in the public side with the private side SOI supporting it. So now, the SOI is the proving of the trust.
Mm-hmm. Well, since I have about a month, is it too late for me to recover from what I didn't have?
No, I think you might still have time if they haven't really resolved the whole matter yet, and it has been more than, say, 30 days from, say, a default.
Well, he hadn't issued the default yet.
Okay, so you could probably, like put this together and get it in there and try a little better approach that is something that they, that they have to pay attention to.
Right.
You need an NOI, cause of action, on the public side, which would be, say, a breach of trust. But then you got to have a trust, and you got to have the evidence to support the claim for the trust. Because they're going to say, well, I don't see a trust here, and that was because you probably didn't have an NOI in there in the public side, and that's why he didn't grant you any.
I think you're right. I think that's what I didn't. Maybe that's the only thing I didn't have.
Yeah, you've got nothing on the public side of the court that the court can see and recognize that you've got any kind of case at all, other than you're just complaining about something.
Right.
It's, which they say you need a protective order, you say, but there's nothing there to substantiate a protective order.
Right. So maybe that was the only thing I was missing, I think.
Could have been, I'm assuming that the evidence you set in there in the SOIs on the private side was correct, but even if it was correct, it still wasn't effective because there wasn't anything on the public side to motion the court to do something.
Well, since I have a month and he hadn't, would I file all new trust documents?
No, you wouldn't have to if you've got the NOIs or the SOIs, to support the claim for the trust, to prove the trust. So let's say you formed a trust. Now, what is your evidence that you formed a trust?
Well, in my UCC 1 and 3, the evidence that I formed a trust?
Yeah, that's your public notices, yeah.
Yeah. And then I accepted the summons.
Now, where would those public notices, where would they go?
Where did they go?
Well, where should they go? They probably didn't go to the right place, but where should they go?
Well, I mailed them direct to the judge.
No. They should have been attached to the notices should have been attached to the pleading to support the cause of action.
Would that not put it in the public?
Not if you noticed it right. Because the notice is nothing more than containment of the RA numbers and no pertinent data or information that breaches the trust. It just points to the records that are being held in private. and that's why we need the protective order, and that's why we need the in-camera hearing.
Okay.
And that's probably why you never got a granting of the protective order, because there was nothing there to protect.
Uh-huh. I was just looking through some paperwork here. But me sending the UCC and the notice of claim, I sent everything to the judge and to the attorney because I thought I was staying in private.
Yeah, you stayed in private, all right, but you didn't put anything in the public that the public could see and act on. And you need to put
I did not put anything in the public. That's right.
You need to put something in the public that to recognize that they can see that they can move with, that they can act on.
Mm-hmm.
But you don't want to traverse into the case with arguing facts. You just want to present substantive evidence, but do it in such a way that it points back to the private.
Okay, now, I had a motion, or the protective order was in the public.
Yes, that should be in the public, yeah.
That was in the case, but that was not enough.
Not without a SOI, or an NOI, excuse me.
NOI.
Which would be a claim for trust, a breach of trust.
Uh-huh. Okay. Do you know where, I went to the law library, and I looked everywhere for the breach of trust. And I couldn't find anything.
Now, it's probably in the forms book.
I had two law students going through forms book with me.
Nobody could find something? Yeah.
Nobody could find anything.
Well, that doesn't mean it doesn't exist, but
yeah.
I'm sure there's breaches of trust out there.
I was at Wake Forest University Law Library.
Yeah.
And we went through book after book. And I also filed a notice, a public notice in the case, by grantor, owner, and holder, and I filed that in the case. I put it in the case.
You recorded it.
Yeah, I recorded it.
And what was that again?
The heading was notice, and then it's this is an actual constructive public notice by grantor as owner and holder of all rights, titles, and interest with a non-negotiable instrument, claim number, blah blah. And that's of course the
right.
case
Mm-hmm.
claim. Wouldn't that have been notice enough?
It might not have been enough to put it in like in a standard pleading form that was representing by a cause of action, which would be the breach of trust.
Uh-huh. Well, I don't know where to find some kind of form. Like I said, I spent a half a day in that law library with two people helping me, and it's amazing. We went through form book after form book. And that's what I was looking for. And that's what I was going to file in the case. But I could not find anything.
Mm-hmm. Well, if we can't find one, we'll have to create it by hand. So that can't be that hard because it's really just the declaration that I have a right and that right was breached and this is a trust. And the trustee breached my right.
Uh-huh.
But we've got to back up and make sure that we've got a valid trust with all the necessary elements, that we've got the notices in there properly, that we have two witnesses to support the NOIs, that we make a proper NOI claim, and we keep them on the right sides.
Did I fax you what I sent you?
Do you have a breach of trust notice to the trustee?
Yeah. Well, I don't have anything on breach of trust.
Oh, well, you know how, if you don't have any records substantiating a breach of trust, then you have no breach of trust.
Well, I don't have a form anywhere that's what I said I was looking for in the law library. I haven't found anything breach of trust. That's what I thought I could file in the case.
Yeah, this is like two different things here we're talking about. Breach of trust would be the cause of action, but that's not the exact form I'm talking about. You want to make up some kind of notice to the trustee that he breached trust.
Right. And that's what I was looking for.
You probably won't find that in court. You know, although you should be looking for in the forms book a cause of action, breach of trust. You should find it there for that. But this is a totally different thing. This is just like a document says that, you know, basically I have a duty, you have a duty responsible to me as a beneficiary, Mr. Trustee, and you have done the wrong thing. You've breached it. You haven't done according to the indenture of the trust. And I'm declaring that you're in breach of trust, and I'm giving you an opportunity to cure that within so many days. And I had sent that notice to him. Now I've noticed the parties that he's in breach of trust. So if I jump into court with a cause of action, breach of trust, with no actual breach of trust document that I sent the trustee, you bring a false claim. You have to have sent the notice to the trustee that he's in breach and gave him an opportunity to cure that breach before you come into court and say, okay, you breached trust. So these are starting to form your records that you need to prove your case that there was a trust and there was a breach. And that's probably what that judge is saying. I don't see any necessary reason for a protective order because there's no proving of a trust here. There's no trust documentation. There's no breach of trust. There isn't even a cause of action on trust. So how can there be any kind of claim or counterclaim against this plaintiff? So I would get something in there going to substantiate your side of the case, or else, you know, they're going to go through with their side because you're not coming forth and defending with the right evidence and actions.
Right. Well, I'll need some help. I need somebody that can review what I've sent and will help me with the breach of trust.
You know, on the calls here, you know, if anybody would reach out to him and give him a hand, you know, I'd get under a trust ambassador if I could, find somebody, get into the chat groups.
Well, can I just leave my telephone number, and if anybody...
You have a Skype handle or maybe an email address, or if you want to leave your phone number, that's
good. My email address is rkepley, Kepley, @earthlink.net. And if they can email me, and maybe someone would be kind enough to help me with it. I'm a novice, but I need to do it now. So I'd appreciate it. Thank you, Chris.
Are you under one of the trust ambassadors in their groups or anything?
Do I know any?
Yes, you're probably not because you...
Oh, I don't know any.
I would search out one of the trust ambassadors, get under one of them.
Okay. Okay. Let me see what I can find.
You have a Skype handle?
Pardon?
Do you have a Skype handle? A name on Skype?
Skype? Yeah, it's just my name. Richard Kepley on Skype.
Can you spell the last name?
Kepley.
Kepley.
Yeah.
All right, so if somebody would Skype him and give me one of the Skype groups.
Okay.
Okay. Next caller, Anonymous, you're unmuted. Anonymous, you're unmuted.
Oh, hi, Kristen. This is Rick from last night. I don't have any. Thank you. How you doing? I don't have any major questions other than I tried to find the June 9th call that somebody recommended on TalkShoe, and they gave me a number, 365967. I spent quite a bit of time trying to find that, but since I didn't have the name of the group, I don't know if I can get to the number or not. And I've put that number in TalkShoe a number of times, and I didn't know if that person was available tonight to kind of give me the group. Somebody said it was Marshall Summary, but when I type in Marshall, nothing really came.
That was Marshall on the call, but that was the number for, I forget what the title of it is, but
I tried searching by date, but there's nothing I can do by date. So.
You might have trouble getting that tape because that's the one for the Wednesday call. You have to be a subscriber onto the Neil Morpheus call. Are you subscribed to that?
To what, sir? Which?
Neil Morpheus on the Wednesday call?
Haven't been on a Wednesday call. Just first, it was the first time I knew about you guys. So.
Okay. All right. So jump on a Wednesday call and get a hold of Matt or Promo from his Skype handle, and he'll sign you up for the. He sends out emails every time the show's over. Then he gives you the email link.
Okay.
And it's a private source thing, so link to get in, and then if you know the number, then you can get to the section where the number's at and download that particular one.
Okay, now you said Matt, or who else?
Matt, his Skype handle is Promorphin.
P-R-O?
Morphin.
Orphan, O-R-P-H-A-N?
Yes.
O-R-P-H-A-N, Pro-Orphan. Okay, I'll try them tomorrow then. Also, let's see here. There was somebody on the, I thought last night, there was somebody on the phone that was from Tennessee, Nashville area, and I didn't know if he was an ambassador or not, but I didn't know if there's a way through the Faith to Trust Skype that I could get through to that or get through to him or talk to somebody, talk to him.
His name was? I forget his name.
I don't recall. I just remember him saying he was from Nashville. I've been doing stuff for about 10 years or something, and he had some interesting court stuff.
Yeah, I don't think he was trust ambassador, but...
Okay. And I got I did get signed up because your wife right before the show, we got connected through Skype, so she gave me a bunch of information there I'll go over, try to get connected that way with you guys. What was interesting to me was that this call, because there was a gentleman, I think, earlier, a couple calls back then from SoCal, and since I'm in SoCal, I was interested to hear your conversation regarding how the county holds the title to the property as beneficiary, and it only, if I understood you correctly, it only changes, even though the title is being sold and used as collateral, if I understood that correctly, to various entities, it only changes on the record when the property is sold or some transaction takes place.
I'm not even sure whether or not it's just, I don't think the beneficiary title ever changes hands. because when we do a successive trust recording, all we're doing is we're changing trustees.
Just for an analogy's sake, for my sake, would it be very similar, what you're describing, would that be similar to when you go out and buy a brand new car, you're given a MSO, and then if you decide to register it, you give that MSO to the state, and they issue a certificate of title.
Yes.
Is that kind of what goes on with the county, with the property?
Yes, same situation. Same model, same trust model, same successive trust.
Okay, so then the house that I own currently, I bought about 10 years ago. It was a brand new purchase. It was a brand new build. It was built brand new. So I was the first owner of it. But the land itself obviously was owned by the builder at some point.
No, it wasn't. Not
no?
You had perfect title.
Oh, perfect. Okay. So at some point, there was an original title to this land in which the builder built upon.
Yeah, that was just that was the last perfect title to whoever recorded it into the county. When they did that, they formed the trust and switched it from perfect title, split the title, and now we got legal title and beneficial title, and it's been messed up ever since.
Well, would this not go back? Then and I don't want to try to mix your stuff because I know you're doing trust versus debtor creditor stuff, but would this go back to my understanding of the original way the government put a lien on all the property when they initiated the zip codes, which expanded to Washington, D.C. to the rest of the country and so forth? Does that have anything in relationship to do with it? Where
I would say so, yeah.
Okay, you would. Okay, so that thinking, I'm kind of on the right track there, thinking that way.
Mm-hmm.
Okay, so then I guess the King or the Bank of England, whoever had the original loan that was given to our founders to pay off the debt, and they put the lien on Washington, D.C., and then to expand that, I guess there was other things that have happened from the Revolutionary times to today that have expanded the King, how the Bank of England's rights to. Am I still on the right track?
That's the title. That's good.
Okay, but when you say the titles were split, I've heard that terminology. Does that mean that, when you say they're split, does that mean that the people who think they own the property are on the deed, but they really don't own the property because it's owned by somebody else, so that's what causes the split?
No, the trust caused the split of the perfect title, and ever since then, since it's always been a trust, it's always been a split title now. And everybody owns the property, and the only thing that they own is they have the possessory title, which is the 9/10 title, but that's the legal title, and the legal title is held by the trustee. But here all along, it's the 1/10 title, the other title, the one that's being held by the beneficiary. That one is the true ownership, even though it's the 1/10 title. So that state or that county has the say-so and the real right to ownership to the beneficial use of the property. They're the real owners.
Okay. Then let's see here. I want to get my train of thought here. When a trust is formed, my understanding was that the reason a trust is formed when I purchased the property is because I took out a loan on my property or to purchase the property. That loan then...
That doesn't have to happen that way, no.
Okay, so what other purpose would somebody...
County trust is different. It's another kind of trust from the one that the mortgage involving the note. That's a separate trust issue.
Okay, then let me ask this question. Then is that why if you don't pay your taxes, the county has superior lien position over the lender.
Yes, because they've got the title. They're the beneficial owners. They have the sole right to the property.
Okay. So then if I guess what I'm trying to understand then is that's a separate thing. The county is a separate trust, and within that trust, if I understand correctly, the lender has placed the trust because I have one called the deed of trust.
All right, they've recorded something in the county. Yeah, it works kind of like they're separate.
Yeah, but if they're a subservient position to the county,
yes.
And so the county's superior position, their trust is all encompassing over the lender's trust, deed of trust.
Yeah, because that came into establishment priority to at the first recording whenever the property came in from a Lodio title or perfect title.
Well, I guess the question then, how and when, I guess it all goes back to the beginning then. So whenever they split the title up, whatever that was, 1800s, 1900s, I don't know. I don't have any idea.
Getting into the county that split the title, yeah, that first trust.
Okay, so is there a way that someone can track that? This parcel?
Yeah, if you do a title search, you can come up with, like your chain possesses titles up to the point to where it went from the old style, I forget what they called, meets and bounds, to the, what's that particular word they use? I forget now. Tiner system, or what do they call it? I forget what the system is. It's gone to current system. I forget what it's called. Well, it's the older system versus the newer system. I forget what it's called. That's how you measure it. Rods and lengths, but it's a Tynan system or something like that. I forget the exact word.
All right, so because I went down to the county and pulled my information, and
plats and it goes by a different system. It goes by plats.
Right, flat maps. I went back to the county to pull my information. I pulled back everything that had happened from the time the home was built by the builder. But I didn't see anything prior to the builder's name on my
yeah, you
house.
probably you can't use the same system to go back into the old system because it won't show up.
Oh, I see. So it's so old. Okay. So there's got to be a way to connect on that. All right.
Yeah, you go by the rods and lengths, and it's the old way of measuring out the property.
All right, so the next question then is just to retrace on something we spoke of last night. We were talking about, because I mentioned that there's a number of us in our group, and two of the people in our group were able to extract the deed of trust from the note. However, I don't think we've been able to perfect what you're teaching here, but what I recall you mentioning last night was that when we create a private trust, we should use one of our registered mail numbers to reference the trust, and when we record the registered mail number as a reference to the trust, that way keeping the trust private, but yet letting the public know that there is something letting the public know that there is something or something going on with the land is the best way I can explain it. Is that basically it?
Notice, but they can't see the real substance. So it's put them on notice that there's something going on there that they should pay attention to.
Now, that clouds the title, if I'm not mistaken. Is that correct?
That might cloud the title.
So if somebody's trying to foreclose and then do a trustee sale, unless they can find out what's behind the registered mail number that was recorded that refers to a trust, they would not be able to clear title at the sale, trustee sale. Therefore, it would hold up any sale, if I'm understanding correctly.
Yeah, no, I don't know if that's going to fit in their proper method of the public way of clouding title.
Well, a title insurance company would not be able to give them title insurance, would they? Unless, I guess they're in cahoots, maybe they are, but it would seem to me if it's a separate entity, a title company is a separate entity, and the lender has to get title insurance in order to resell the property, in order to clear the
would have to give due diligence search and see what your response was, and then if it didn't fit their pigeonhole, then they would probably ignore you being, a false claim.
True, but then wouldn't you be able to submit that on the private side into judges' chambers to let them know that this is unlawful?
Absolutely right.
All right, so that would be the process, or some of the process.
It's your foot in the door, your toe to block the door from going closed, but yet that gets you in.
Right. So then the judge, when he comes out of his chambers on the day of the hearing, is he allowed to address what he read in private, or does that have to stay in private if you've given it to him in the private under seal?
Yes, that's what the protective order is for, so it maintains its privacy, so it doesn't get publicly noticed. So there's no crossing, there's no commingling.
Right. So then he just has to, I've never been to court, so I don't have any clue, but maybe you can give me some hint as to what might a judge say then once he receives something like that in private. He comes out and the lender's attorney is sitting there wanting to, foreclose the case and move me out and so forth. What's the judge typically going to say? Or what does he have to say, or by law?
Well, basically, it's a different law form and it does not apply to that law side. And it's
right,
a higher,
that's equity. If I understood you correct, the chambers is equity?
Yeah, equity is a higher law form over common law.
Versus common. Okay, but I thought when you go into a proceeding, one of these cases where they're foreclosure or detainment, I thought you called it a statutory type of law?
Statutory is at law side, the public side.
Yeah, so when he comes out of his chambers, he's in statutory law at that point?
Yes, he's back out in the court, yeah. He's on
right,
the public
so then when he's back out in court, then the attorney for the lender then is saying, okay, Judge, let's get this thing closed, we've got everything in order, and the judge has to do what at that point?
He can't operate because the evidence is on the side, and the equitable side is the higher law form.
So then he has to dismiss the case.
Yes, because your equitable act made the payment.
Okay. All right, but it would seem to me that there's a lot more I need to know about that. It sounds pretty simple in my mind. Maybe it is that simple.
Yeah, let's put this with a model-wise, but then it comes down to the switches and things that need to be put in the documentation to make sure that we got the equity and stuff, just like the last fellow that was saying.
All right, so how does one learn all that information to properly execute under seal a private thing to the judge? I know everybody's been doing this for years. I haven't. I don't have a lot of time to get 5-10 years experience under me, so how do I get coaching and understanding to get to that point where I can effectively do that?
I'm going to say the last 6 to 8 weeks when we've been talking about equity, when we've been discussing out of the Corpus Juris Secundum, Book 30A, we were talking about, how to get into a court of equity. So this information has just been coming out, and this is just probably what we need to know to get in our pleadings, so that we know what to do to get into and invoke that court of equity.
Hmm. So you said the word book 30.
Yes,
What does that pertain to?
The Book 30A is Corpus Juris Secundum. And all libraries got Corpus Juris Secundum. 30A under mine, the copyright was 1955.
Corpus Juris, what did you say the last word was? Corpus Juris?
CJS, Corpus Juris Secundum.
I'm having a hard time. Conundrum?
SEC.
SCC.
SEC.
SEC, like section.
Yes.
Okay.
UND.
UND. Mark. Okay. UND.
Secundum.
Secundum. Okay. And that's Book 30A.
Yes. 1955 is what I was reading out of.
1955. And that's in a law library. It should be in a law library. Okay.
I believe we've been scanning that, so that might be available.
So when I get all hooked up on Skype with you guys, I should be able to tap into some of this information then.
Yeah.
Okay. All right. That gives me enough to ponder my brain here for. So hopefully I'll get back and get to be able to get on. Well, tomorrow night I'll get on with Matt on his show there or whatever, and see if I can't get that June 9th talk show. But thanks a lot, Christine. I'll continue to listen and hopefully gain some more knowledge. Thank you.
Yeah, to get into Court of Equity, to pull it off the top of my head, I might be missing a few things, but it's on the past show recordings over the last, say, 6 weeks or so, when we talked about the Corpus Juris Secundum. But anyway, it's when we were studying the Lewin book that we're still studying, it was by the subpoena that the trustee was summoned into court to answer to the benefit. But it's a counterclaim, and a counterclaim we found out is solely equity also.
Mm-hmm.
Come in as a counterclaim, your counterclaim would be, say, breach of trust to this claim. So that counterclaim puts you in equity already. But we want to put in there, the true counterclaim has to be a summons listed. So you've got to pay the filing fee for the summons to be issued, and the sheriff issues the summons. You've got to respond to that you put in the counterclaim, or else they'll be defaulted on that alone.
So on a true counterclaim, they get 20 days to respond?
Just like you had 20 days when you got served.
Okay.
You got to pay the fee for the filing, and then the sheriff has to serve that summons.
Who's serving it to? You're serving it to the lender's agent? Because
the trustee is probably going to be the plaintiff.
I'm sorry, you broke up right then. What'd you say? I'm sorry.
The trustee is usually going to be plaintiff in the case.
Right. But they usually have a person you have to serve. You know, they usually have an agent for service. So, in other words, like...
That'll be your trustee, yeah.
Yeah, so the trustee is like B of A, so Bank of America... Well, actually, in my case, it'd be Recon Trust. And then they may have, or usually they have, somebody that you have to serve that receives all those types of things. So I just want to make sure that I don't serve Recon Trust.
Oh, he's the head. He gets served. Now, whether he's got somebody under him that's going to accept that or whatever, you know, that's probably the guy that's going to get it. But my trustee is that guy in the bank, the CEO.
Okay, then I guess I'm confused. I guess I'm a little confused at this point. Then I apologize. I understand you have to serve somebody, and you're saying you serve the trustee. What I just heard you say was that the CEO or CFO would be the trustee of the bank.
No. That's my trustee of my trust, and he happens to be the CEO of ABC Bank.
Okay.
And they are probably the ones that are coming at me for, say, collection.
Okay.
They're the plaintiffs. Now, if it's another party, you're going to have to join them also.
Well, what I've been doing is I've been notifying my lender, the servicer, the trustee, and the beneficiary, and the current lender, because my original was with Countrywide. Of course, they've been taken over by B of A, so I always make sure whatever I send certified to all parties that are involved. I don't know, maybe that's overkill, I don't know, but that's the way I was suggested that I do it, so I've always been doing it that way. And I usually use notary certificate of service or notary presentment to do that as a third-party witness. Obviously, they ignore most of all that and so forth, but if I'm understanding you, my counterclaim is going to say something to the effect that I reject the claim that they're making to me, and that...
No, I'm not rejecting that claim. I'm coming in with a counterclaim, and my counterclaim is there's been a payment.
Oh, I see. There has been...
There's been a breach of trust.
A payment and a breach of trust. Is that what I heard you say?
Yeah, there's been a payment. Now, if it's not record or ledger, and there's a breach of trust here.
Breach of trust. But now they're going to ask me to prove that.
Absolutely.
Now, when I go to prove that, how do I do that? I mean, I kind of understand. See, I'm thinking from the debtor-creditor side. I would say, well, my straw man account, it was paid there, but you'll never get the information from them on how they got paid from the Federal Reserve through your straw man account. You'll never get that. So, I mean, how do I guess it comes down to, what it sounds like to me is it comes down to, I really need to understand trust and how to operate in trust. Is that a correct statement?
Yeah, you need to know how to effectively create a trust in order to claim a trust. And then you have to know how to create those records to prove a trust. And he who claims trust has to prove trust. So when you come in and you claim a trust, you got to have the proof of the trust.
Okay, so then what I've done thus far, but have stopped because I haven't been clear on moving forward, was to serve notice as a grantor, as a grantor on my property, that to all the people I named earlier, beneficiary, servicer, trustee, that I was in the process of modifying my deed of trust. I sent out that notice. I waited about, I think it was 5 days, and then I sent out another notice, second notice. And of course, when I sent out the notice, it wasn't just that. I put in other information like they haven't done this, that they've been in default on certain things. I listed a bunch of things that were in default and they haven't executed on, or the breach, as you would say. So then the second notice went out, and then no response. So my third notice went out saying that I was modifying, but I haven't recorded it yet, but I was changing the trustee. And I put a person's name as a trustee and the name of the trust, and I sent that to all parties. Have not recorded anything. Didn't think about putting the registered mail number on that. But that's what they all have right now. So I guess at this point, it sounds to me like I'm kind of on the right track, but I need to just go ahead and record what I have, but use a registered mail number and then keep all the documents that the proof of service and all the things that they've received, all that information that I would warn them about. And then I have my private under seal document ready to go to give to the judge when and if that comes about. Is that bad thinking, or am I on the right track?
Well, to substantiate any claim or any NOI, you have to have two witnesses. And those two witnesses are those two records Those are your SOIs.
They're my SOIs?
A statement of interest.
Okay, let me just write that down because I wasn't sure. You mentioned it earlier. SOIs equal statement of interest.
Those are your material facts. Those are your records. That's your evidence.
Now, they were... I'm sorry.
You need two records to substantiate any claim or any particular...
So I've done two. That's good. So what does NOI stand for? Notice of intent?
Notice of interest, yes.
Oh, notice of interest. Okay.
Notice of interest is the claim.
I see. Interest equals the claim.
So for any NOI, I must have two SOIs to support it.
Must have two SOIs to support.
And all that is just biblical, because to substantiate any fact or claim, I got to have two witnesses, two records.
Now, you mentioned earlier, real early in the conversation, I thought, maybe I'm wrong here, something about notaries are public. So when you notarize, you're actually making a public declaration. Based on the basics of what I've told you just so far, am I in public or am I in private?
No, we're using the notary just to do a presentment so he can just have an arm's length, clean hands, third-party witness.
Right. That's exactly what was the purpose of. And then, of course, they notarize my signature on the letter, which is an acknowledgement beyond that.
Yeah,
but,
so that's making it seeable in the public, yeah. So, but we're using a UCC1 to claim, and then we're using a UCC3 either to move the title as a withdrawal or to move it in the hands of the trustee, depending on what we're doing. So we're going to do a UCC1, and we're also going to do an equivalent, because your UCC1 is an SOI, but you need two SOIs. So you need, say, a UCC1 and a county record, county recording.
All right, so now I've filed, again, using the Tim Turner process. My wife and I both filed UCC documents. We got our numbers, and we did the full UCC1 package. We've sent that off and recorded that. That's all been recorded. And our property address and all that was part of my property.
Okay, but here's the thing. The recordings on the UCC1s and the counties, those are just notice filings, and they do not contain any private information. They only contain RA numbers pointing to the private documents.
Okay.
Enough information to make a notice filing. No pertinent private information on these.
Okay, so then when I
otherwise just crossed it back over into the public and made it public again, your private documentation.
Okay, let me just see if I can understand here. When we did our UCC1, we got it all done with the state, and then we put all the information together in a packet, and we went down to the county and recorded it. I got a recording number.
What did you record?
I recorded my property list that I had filed with the state. I recorded an indemnity. Let me just, if you give me a second, I can pull it up exactly. Let's see.
So it contained all your private information?
Yes.
No.
Not good, huh?
No, not good. You just gave the county back all your property.
Really? Oh, man. That sucks. Sorry. Okay.
Anytime you bring your private information into the public, you waive it, and it's like you give it to them.
Really? Okay.
You commingled the private side with the public side, and you breached your own trust.
Wow. So we can cancel that. That's my understanding, right? I can do a cancellation on that UCC and start over?
Yeah, I would withdraw that, cancel it, and then just put notifications in there and keep that stuff private.
Yeah, because it has, I sent off a affidavit, a recording. I sent off an act of state, power of attorney, commercial security agreement, indemnity bond, hold harmless indemnity agreement, non-negotiable security agreement, legal notice and demand definitions, affidavit of political status, act of state, apostilled, chargeback order, fiduciary appointments.
You did an act of state?
Yes.
You know where that came from?
No, sir, I'm not exactly sure.
That came from me.
That came from you?
Yeah.
Okay.
Nobody used act of states until I started using act of states.
Okay. Well, I didn't know that, so I'm pleased to meet you. We did a chargeback order. We did a fiduciary appointment for the Inspector General, and then Timothy Geithner, Secretary of Treasury, Douglas Schulman, Commissioner. We did a 1040V. We did an action.
A lot of that stuff is debtor credit. We don't need it, but
we did a birth certificate, stamped it, and all that.
You need two records or two witnesses to substantiate any of your claim. So we use the UCC1 in the county to claim the title as being yours. Now it's yours. You can do something with it. Now we can move it. And what we do is we use the moving titles platform, which is nothing more than the UCC as a non-UCC filing, by the way. It's just a notice filing. And we use the county as the two witnesses, and we use the UCC3 and the county also for a second witness on the moving of the title. So first we claim the title, and then we move the title.
Okay.
And that's what the moving titles platform is all about, moving titles. First you've got to claim it on a 1, and then you move it with a 3. And those are just notices of the movement.
Okay.
This actual delivery by mail, that's the formation. But the notice is just the UCC3, and that's just a notice filing. No mechanism that forms anything. It's just a notice.
Okay. What I was reading off, and I apologize, is not the fiduciary stuff was all done in my Section 2 docs with the bonds. Act of state was the last document that was recorded. So we did the UCC, we did the addendum, the property list, power of attorney, commercial indemnity bond, all the way through to the act of state, and that was what was actually recorded.
Yeah, well, what you under the debtor credit thing is you're creating a lien, which is another negotiable debt instrument that mounts debt up.
Right.
And it really doesn't discharge anything. You're just using it as a public set-off.
Okay. But isn't that, well...
What we found out that debtor creditor has no more than, say, less than 10% success rate. And the reason why is because in Gilbert's trust law book, it says there was a discretionary trust that was formed, a protective trust, that the assets were put into protection, and the trustee on the trust, who is holding all the assets, whether that would be the alien property custodian or Geithner or whoever, that trustee has discretion whether or not there is any success or not. It's a discretionary trust. And that's the reason why there's no more than, say, 10% success rate, which just is enough to keep everybody on the path because somebody wins. But after 20 years plus, the debtor-creditor field ought to have by now a higher success rate. And ask yourself the question, why? And that's answered by the trust. And the trust is the answer because it's per the discretion of the trustee on a discretionary protective trust. Because in 1933, all the assets went into protection because if the beneficiaries got their assets, the creditors want to seize the assets. So to protect the bankruptcy and the assets in the trust, they formed the trust and put the assets in the trust to protect it. So that was a protect trust. So that for the purpose that the creditors couldn't get at the assets. Then they formed a discretionary trust where the trustee has discretion whether or not the beneficiary gets paid anything.
Okay. All right. Then
trust.
You broke up. What?
It's like a spendthrift trust.
Okay. So at this point, we've sent off our Section 2 stuff to the Treasury and so forth.
Where'd you mail them to?
Tim Geithner.
See, Geithner's on the public side of the Treasury. He's under the public debt system.
We sent it there. We sent it to the Inspector General and to the IRS Commission.
We do everything totally backwards from what you're doing.
Okay. So what it sounds like I need to do is redo what I've already done. And so I need to, how do you...
Well, we can what you've done by merging that title, that debt title that you've created, that debt that you've created. Mm-hmm. We can merge that with the equitable asset, and we can take care of that. We can terminate that.
Okay. Am I going to have to be able to, will I be able to talk to an ambassador, somebody to help coach me through that? Or is that just something I'm going to have to figure out on my own by listening to all the tapes?
Well, really, you need the past tapes to get you up to speed because there's a lot of fill in between that we're not talking about, and a little picked up, here and there, and by that time we'll be farther along than we are.
Okay. So you would probably recommend that I don't do anything further, like send in my indemnity bond, which is the next thing I need to do in the Tim Turner process.
Well, here's what I look at. All this debtor-creditor stuff that everybody's been doing, including me in the past, does the same thing. I know exactly. Been there, done that. You got to realize that all you're doing is you're creating more negotiable debt instruments, which is debt. And you're mounting more debt up on top of debt, thinking all along that you're getting a remedy or you're doing a set-off, and it's not.
Well, my understanding was that when the straw man account was set up originally on our behalf at birth, or when our Social Security number is given to us, that the government really doesn't know what amount that account is worth. So all we're doing is when we file this bond.
You really believe that the government doesn't know how much money you got in the account? What's the purpose of the IRS?
Yeah, that's true. They need to know things.
They got history on you since the day you were born, and they know more about you than you know about yourself, and they're not talking about it.
I guess the idea was that it had been the information, and my birth certificate had been sold so many times or traded, and that the interest on there is variable, that they don't have a way of tracking it.
No, I don't believe that at all. I don't believe that at all. I believe they know exactly what's in that. They've got to.
Well, it would seem odd because, just for conversation.
How would they control the money supply, the M1, the M2, and all that stuff? They got to know.
Well, except that how would they be able to track it? I'm just as for conversation here because I'm just trying to be devil's advocate so I can learn. Back in the 30s, we didn't have computers like we have now, so everything would have traditionally been on either an adding machine of some type or hand calculated. It wasn't until the 50s that we started getting some type of computer. So it would seem plausible to me that at some point they may not have an exact accounting. They may have an estimated accounting of what we're worth.
Or it could be that maybe we weren't that necessarily involved in it, and the hand calculators kept up with keeping track with it all.
Yeah, well, I guess that's true. There's only two possibilities, but I know they either have it or they don't.
But really, the points are really irrelevant. If we're doing business according to GAAP on the public side, then it's debt upon debt, and we're mounting debt up.
Right.
And here all along we thought we were accessing this trust and doing a set-off against this trust, but yet we weren't claiming trust, improving trust, and if you're claiming trust, you've got to operate as a trust. That's right out of restatement of the laws and second, and corpus juris secundum backs that up.
Okay.
So if you're not operating as a trust, how can you do a trustee payment? Can't. So the only way you really get rid of the debt is by operating a trust and doing merging of titles. Not debtor creditor, claiming you got a trust but never proving a trust, and not operating under the office of trustee to have the right to make a trustee payment.
But what if your debt doesn't have a title associated with it, like credit card debt? How do you...
The title is the man's name and the account number. That's the title.
Oh, I see. So we're not, okay, when you say title, okay, because I'm thinking title meaning, you know, property or a car.
No, a title. I can have a title to a cup. All I do is give it a weight, do a survey on the cup. It's a color blue, it weighs so much weight, it's measured so high, so round, you know, I do a survey on it. I'm doing the boundaries on the cup. I'm creating a title. And I put an RA number on that title. And now that RA number represents that title, that cup.
I see. I gotcha.
Now I can move that title after I claim it. Claim it on a UCC-1, now it's mine officially. Public notice.
All right. So when I
do a 3 and move it to you. Now you got my title.
A UCC-3 allows you to do that? Is that what I understood you to say? A UC3 filing a UC3 C3 allows me to switch the title?
Yeah, I moved it to you. I sent it to you prior to the filing of the 3. You got it by mail. That was delivery. And delivery is one of the methods of formation of a trust.
Okay.
Now I do a UCC3, which is the notice of your delivery that you got, and we've got a trust, and you never knew it.
Okay.
As I said, I'm going to send you my cup, but I want my cup back sometime in the future, along with my interest.
Then just going back a couple steps here then, based on the UCC information you're saying, then it was not improper then for us to send our property list to the Secretary of State.
No, you're creating debts for them that they love and they don't tell you about it.
So by sending a UCC-1 with our property list to the Secretary of State, we've created debt?
Well, according to the process that you're doing, you're creating a negotiable debt instrument. You're creating a lien.
Right. All right. So then
you're mounting debt up, and they love it because they're using debt as money. So you're creating money for them.
I see.
Here you're creating money for yourself.
Well, then going back to your example of the cup, if you're filing a UCC-3 in order to transfer that cup to me, and that's part of your property list.
Okay, but I didn't get you in a lien, and I've got you in a trust. A lien is under debtor creditor. It was a general deposit. Mine was a deposit. And I'm on a different floor, and my law firm's higher than yours.
I gotcha. Trust is a higher law form.
Yes, page 19 on Lewin's book on Practical Treatise on Law and Trust.
What's the name of the book, please?
Practical Treatise on the Law of Trust.
Practical
Lewin.
Treatise.
Page 19.
On Law and Trust.
Because when there's any discrepancies between equity and common law bows down to equity.
Wow. All right, so that's why the lenders can continue to do what they're doing, because the deed of trust is trust.
Yeah.
But we're trying to attack them outside the trust.
For instance, is a statutory trust there, not a private trust.
Yeah, they're doing a statutory trust, the lenders.
Well, no, you're doing it because actually, that deed of trust they're talking about there, that's really the security agreement right there.
Yeah. So that's statutory, and what we're trying to do is get them to get put our property into a private trust,
Yeah,
thereby
non-statutory, although we can play in both realms.
Yeah.
And you could probably win under a statutory trust just knowing about trust.
Okay.
But you could do a duality system, claim statutory trust on a public side, but claim private trust on a private side, and run both processes simultaneously.
Okay.
That way you have a colorable face mask on the public side that would mask what you're doing on the private side.
Okay, well, that's starting to get a little technical now. I mean, I got to get down the first part first, but all right, that's very illuminating. So then listen to the previous calls in order to understand merging and the trust and how it works, and then I can approach an ambassador to talk about merging the stuff I've done already in the public with a private solution.
Yeah, and NTT is really simple. It's just, merging titles, extinguishment of debt. That's it. That's NTT.
Mm-hmm.
But then NTT rides on the moving titles platform, which is two notices, one being a UCC1, say, an accounting. Mm-hmm. And then we came up with that. And then we do another UCC3 with another county, and that would be the moving of it.
Okay. Now, if that goal, and I ascribe to this goal, and this is the whole point of getting involved in this, is to eliminate our debt and being a debtor and not causing more harm, how does one go about purchasing big-ticket items like a house or a car down the road? If you need a house, if you got to move to another state, or your car goes out and you need another car, how do you do that without creating debt or more problem?
Okay, you listen to that 1/26/2010 tape, and I do one complete hour from A to Z on how to do that.
Okay, I just wrote it down, so once I get into the system, I'll do that.
Basically what we're doing is we're terminating the strawman account. We're going to, the remainder that's going to be left, we're going to put it into a new private account that we order into existence. Mm-hmm. Then we're going to take a broker, and we're going to cross over, cross over, that's a bad term because nothing crosses over. We're going to have a broker generate interest off of the private side assets. And he's going to generate this interest, and he's going to put it into a new trust that we set up on the public side, which is going to be after the strawman account is terminated. There's no connection with you whatsoever, but yet you need to interface back in to do, I wouldn't want to call it commerce, but what we're doing is we're just participating in being a consumer, mm-hmm. consuming goods produced in the public, but yet never doing commerce again. But that interest is then put into this new public trust that we form. That interest is deposited into that, and then there's an LLC that's a trustee on that private trust. And you live for the rest of your life operating out of that LLC, that second public trust, off that interest.
Okay.
And that's a checkable, just like you write a check today on the interest, it's credit that functions like everything else, and you don't know it any different from anything else, and it raises no flags.
So you can actually pay your electric bill and phone bill and all that with that, right?
You just write a check out of your interest. Out of your, yes.
Okay. Another question now. So another light bulb goes on. I currently have an S corporation that I set up. Would it be wise to get rid of that, or to keep or maintain it, or because I use it for business?
Corporation hasn't done any income or business effectively connecting with a business or trade in the United States, which makes it taxable. And then I'd say if it hasn't, then you could probably use as a substitute for this LLC on that trust. If it has, I would want to terminate it along with the straw man stuff.
Well, I can do that. I can terminate that. That's not a problem. I use it like I said, as a shell for my business, and I run all my income that I would get through that.
But see, if we're writing checks, doing credit cards, and generating profits and things like that, that's all debt. And what we're doing is we're mounting debt up.
Right.
And we're doing commerce. So we don't want to do commerce anymore. So we're just going to consume goods that we need off of the interest. And we're never going to do a business or trade, and we're not going to do commerce any longer. Otherwise, we'll be commingling and breaching our own trust.
Right.
And they'll probably end up taking these assets that we've generated away from us.
Okay, because one of the, boy, all right, I've got, my mind's overload here, so I've got to move on just so I can reflect a little bit more on what you said. It's been very helpful and very informative, and I really, really appreciate that. And I'll let somebody else have the floor for a while. You've been very generous with your time, and I just want to thank you for that. And, man, okay, I got a lot of work to do in the next few weeks.
Okay.
Thanks, Christian. I'll stay on the phone until whatever in the call. So thanks.
All right. We got time for maybe one more. Who?
Yes. Do you have a trust ambassador in the state of Mississippi?
I don't think we do, not in Mississippi, but I got something around close by you.
You do? Okay.
You have a Skype handle you could give us?
Huh?
You have a Skype handle you could give us?
No, I don't. I'm kind of new to all of this. I can get one and get back with you on the next call probably, because my son does my computer for me basically. One other thing I wanted to ask you was that you said that the creditor-debitor side of the Tim Turner had like a 10% success rate, depending on the trustee has discretionary trust. Has your trust setting up that you do with the trust, has it been in operation enough to know what success rate you have with it?
Well, we're starting to see some success. We've only been about 7 months new into the MTT process, so it has a 20-year jump on us.
Mm-hmm. You have been in the debtor-creditor side of the program before you started? Yes.
That's where I was born.
Mm-hmm. And
I've had success under debtor-creditor, too.
Do what?
I've had success in discharging under debtor-creditor also.
Mm-hmm. And you think the trust is going to be much, much stronger and a lot more successful than the debtor-creditor?
Yeah, in a way it was kind of a blessing that I started out in debtor-creditor, because the more I started studying trust, I could see, well, it all fits together. It makes it like fit together.
Mm-hmm.
There's like, under the debtor-creditor, whatever method you're using, there's types. And with the trust, it all comes together. Really, if you study the trust, you'll see that.
Mm-hmm. Yeah, I've been listening for several nights on the call, and I've picked up a lot of information that I didn't know, but it's beginning to kind of blend together now to look like the trust is.
The trust doesn't have any greater, the debtor-creditor, the fact that it doesn't have any greater than, say, 10% success. When we started studying and getting into the trust, and we discovered the discretionary trust, we knew right then that was the answer why there was no more than 10%.
Mm-hmm. Mm-hmm.
It was per the discretion of the trustee.
Mm-hmm. Which is on the public side.
Yeah.
Okay.
Mm-hmm.
And that's Timothy Geithner.
So it's like a nose ring leading a bull around the mountain, wherever he needs to be led.
Wherever he wants to go. Gary.
Mm-hmm. But never up the mountain.
Mm-hmm. Okay. I guess I've been listening for the last good while about the guy that you was just talking to. the trust program, is it a lot more expensive, a lot less expensive? I see that there's a lot more studying to do, a lot more information you got to compile and put together to know what to do and what not to do. I can already see that. But as far as the actual money that you're spending on it, how does it compare with the other side?
Probably no more expensive than the rest, I'd say. You're not. We're filing online. It only costs $5 to file at UCC. It's not so critical that we have to file in a particular state, but which may be higher. We're going with the cheapest one, which is $5 for those. So
ends up being about the same, or if not a little less, then.
Yeah, we're still using a notary for different purposes, but not quite the same.
Mm-hmm.
We're just using it for witnessing and.
Okay. All right.
Because we're not filing all that paperwork into, say, the county, and they're getting you, say, for, $10 a page or something.
Mm-hmm.
So all we're doing is filing maybe a one-page notice.
Mm-hmm.
So, these are minor expenses, though, really. But.
Where would I, other than listening to these calls, where would I go to talk to? Would I get in touch with your wife, or where would I go to get more guidance on information, or an ambassador that's close to Mississippi, or whatever?
There's just the other calls that we're on. Try to get hooked up with in the chat groups. Get hooked up with a trust ambassador. Listen to the older recordings since 11/7, 2009 and forward.
Mm-hmm. Okay. And
moving along at our own pace here, so.
Are those all on the website that I can start? I know I pulled it up the other day, and I noticed like the ones on 11/7/09 we had started listening to those. But are they in sequence on up till now on that?
Pretty much so. I think there's some in there that the newer ones might not be on there, but they're accessible through either that source or others.
Mhm. Okay. And to get in touch with the ambassador, best to get a Skype name and give it to you, or you can forward it.
Yes. Mm-hmm.
Okay. All right. I sure thank you, sir.
Okay. I guess we got one more.
Hello?
Minus, you're unmuted.
Oh, yeah, it's Jacob. How you doing?
Jacob, hi.
I just had, God, you went over so many great things tonight, Christian, and all the guys out there did such a great job. It's very impressive. I had a question. Let's see. Boy, I took so many notes, I covered up all my questions. Let's see here. Well, I guess, let's see here. If you, if somebody gets drug into a court case real quick, and they don't have a lot of time to do things in the proper order, is there any shortened form of NTT that we could implement? Let's say somebody, has waited forever for whatever, and all of a sudden they've got a court case in 5 days. And so now what do we do to help them?
About the only time constraint that I could say that's possible is that when you give them a breach of trust, that you give them an opportunity to cure it such and such a time. So,
how much time do you give them to do that?
I would say minimally 3 days.
Yeah, that's what I thought. So that's exactly okay. Write it down. 72 hours. That's what exactly looking. That's a good confirmation. Okay. And so 70 hours breach of trust.
And everything's all operating in public as commerce. Commerce is 72 hours. So.
Well, I got caught in one of those things this last week, and I actually had to do I had to transfer a trust property into a trust, and do the records and what have you. And the next day, the next morning, 9 o'clock, had to be there with all the stuff because it was in a court situation, and I just
you can always ask for a postponement for good cause.
I did get 10 days for that.
10 days enough to to get this stuff put through to where you have the records created.
Yeah.
The time at all to do a UCC1 or a 3 filing, and how long does it take you to record something into the county?
An hour. Oh, in the county? Yeah, an hour.
So there's no big deal. It's just that you have the breach, do you have the time for the opportunity to cure, do you have the trust documents already put together, because that's, it's just...
Yeah, in this instance, there was already a lot of good stuff in all the things that needed to be done were done, which was good. There was a certificate of dishonor to utilize. So, but there wasn't the breach of trust. You know what I mean?
Right.
So, and then there was a paralegal that was involved that had gotten a pre-answer motion, and then walking into that, and then you can't add anything to it. So,
the only time constraint that I could see would be the opportunity to cure, or if you did a debt validation, which would require 14 days, and then that might stretch out to 21.
Mm-hmm.
So that would be without the debt validation, you could probably then say a 3-day, 4 days constraint period. But if you had the opportunity to cure that already in there, then it's just a couple hours.
Yeah. Okay. Now, this is kind of different than we've heard anybody ever discuss or anything, but there's a situation that came up where a party's mother passed away a couple weeks ago, and she has an enormous amount of assets, okay? Several, homes, dozens of stocks and bonds accounts are with banks and this and that, and there's, there's a guy who's...
lots of debt, in other words.
Huh?
She's got lots of debt, in other words.
Yeah. Well, she's got lots of mounted up debts inside those accounts. And the thing is that some odd circumstances with this gentleman, and make a long story short, his sister kind of moved in there and started working away with the so-called executor. The executor had done, and the sister had done a lot of things where they didn't have authorization in the trust, okay? So he has to come back in there. So there's 2 siblings that are left over. 2 had passed away also, and so there's 2, let's say, and it's split down half. This trustee has been absconding with these funds. She went in and she changed the woman's name to the name of a trust and transferred them from the person's name into the trust, and now the gentleman wants to know, how he could get his fair share. So I thought about it quite a bit, and I thought that, let's say there's a Smith-Barney fund, okay? And the Smith-Barney fund, is tied into with Citibank. So what's happened is
it comes back to this. What does the indenture of the trust say, and what powers were granted to the trustee? The trustee has total authority to do what they did.
Yeah, but you know what? They
the trust indenture.
Yeah, but get this one. I think they put a fake document in, okay? Because there's 2 documents that are actually on the same day, which is the trust indenture, and there's a will. And the will totally contradicts totally contradicts the trust indenture. It's almost like the opposite of it. So the will, which names the two beneficiaries, and then the indenture, which names the two beneficiaries and is very clear, and then the will reverses it all, and they're on the same day.
It can't.
I know, but that's the story. I mean, that's what I've got to deal with.
If there was a valid trust, then the trust, if it takes priority over the will, then...
Would the trust take power over the will?
Yes,
if they're on the same day?
And the trust was transferred, the property was in the trust, then that's it. There's no...
Yeah, the property's all the properties are in the trust.
There's no property to be willed after that.
Okay, so you understand they're both on the same day, right? Signed on the same day.
Yes, but one has to take priority over the other.
Well, would the trust take priority over will?
You'll have to find out when the timing was on the trust property when it was transferred into the trust.
Okay.
And when was the will signed?
Yeah, it's the same day as that trust, and that shows all the trust res going into that trust. I mean, it might the trust res might have gone to an attorney's office, huh?
Wrong. There's something wrong because if there's two documents that are that close together and they're contradicting each other, then there might be collusion in there. But you got to find out the specific times on the day which one happened first.
Okay, that's a very good point. Okay. I want to ask one more question. On a mortgage deed of trust, when you express the indenture, what is the position about modifying the beneficiary position and then adding oneself as a remainder beneficiary and making the so-called alleged lender the income beneficiary? You just modify the mortgage.
The grantor has to do that.
Yeah, I'm saying the grantor would do it.
All right, so now what again? They want to change the beneficiary to some other what?
No. Modify the mortgage to have a second beneficiary. The grantor would be also the beneficiary.
Well, the mortgage would be the debtor creditor contracts and things, and those probably can't be changed.
No, but when you express the trust, here's an example, okay? Like in, let's say the so-called third-party debt collector comes at you, and they're supposedly representing an alleged lender or whatever. But anyways, to make a long story short, they've got a case that's coming against you. And they're coming against you they're only coming against you for the mortgage deed, and they've left it.
Can't do that. It can't foreclose.
No, they've already foreclosed. They've already had an auction, but the title it never went through. The auction never went through because
if they didn't have the notes.
They did an auction without the note, and then it didn't fly. And it got thrown out, and then now they're coming in with a quiet title. Huh?
The mortgage follows the note. The note is first. If they didn't foreclose on the note, they couldn't foreclose.
But if they split the note, which is what they've done,
you can't foreclose.
Don't you have two trusts floating? Don't you have a note trust and a deed trust?
No, they're not.
If they split them up, which they do.
Now we're not talking trust. They're foreclosing on a debtor credit contract.
Yeah.
It's got nothing to do with trust.
Right, but I'm talking about if you're going to express the original trust and they're only coming at you for the deed when you express the trust.
Yes, but they're foreclosing not on a trust. They're foreclosing on a debtor creditor contract.
Okay.
Which gives them the right to foreclose is they've got the note. If they're not owning and holding the note, then for whatever reason they can't foreclose. If it's been securitized, If they split the note from the mortgage or the deed of trust, there's no way possible they can foreclose legally.
They don't care. They don't do anything legal. What can you say?
Well, yeah, I can say, yeah, they don't do things according to the rules, but then we don't know what the rules are to stop them from breaking the rules.
Well, in this case, they just went right past the rules. And now with the quiet title, they're only coming back on the deed.
There's you're in for vacating the judgment then. If you got evidence that they broke the rules, then that's a void judgment. That's a vacate judgment.
Okay. Okay, Christian. I'll think about that. Try to work on that from that angle.
All right.
Hey, thank you. Bye-bye.
Thanks, Dick. Okay, Chris, you're up.
Hi, Christian. How are you?
All right. Getting ready to cut out.
Yeah, I hear that, and I'll try to make this as punctual and as short as possible. I have quite an interest in and around subject matter that even Jacob was even speaking about, and I'd like to have you at least share your considerations in and around beneficiary and how you read out some of the subject matter around our land trusts, private trusts, and our land patents, and how we can change the status. I think the most important part here is mostly dealing with what you were saying earlier about the county being the beneficiary and how they caught the ball. Now they're running with it, and it was fair and square as far as the comment was made at that moment. But to me, that if an individual sells a property to you as the new grantor, and as we saw 7 or 8 months ago when it first came into this forum, a trust was a little bit like a will, of where the grantor and the intent of the grantor has the ability to change that will, to change the beneficiaries. And I think what would really help me is for you to do a little bit, in clock it minutes, just a quick synopsis, how we would go about after obtaining like the land patent and becoming the grantor. What would we do in its preciseness of being able to obtain the beneficiary rights back away from the county, out of their hands, and how we would deal with response and or separating ourselves from the property tax and putting that bond in place. If you could do a little spiel, 5 minutes, man, that would really help me a lot because I'm intrigued. You caught my attention. I'm ready to finish off some of my thinking that's going on here. Can you do that?
Well, I don't know if I can do it in 5 minutes, Chris.
Well, I know it is, but can you at least make an attempt? Because my mind is like, it's been wrenched.
That's a whole
My mind has been wrenched for weeks looking at the same question I just asked you.
Well, you know, the reason why some of these allodial titles and perfect titles aren't effective is because the trust in place. And you've got to terminate the trust in order to bring the perfect title forward. The perfect title is being blocked by a trust.
Would you say that that's the deed of trust that is the lien that's been placed there by the claim of title?
You might be able to look at it. That's a lien put up against it.
Or would you say that the county, being the beneficiary, is a different trust that supersedes the trust that you could ever put claim to that would perfect?
Yeah, the county takes precedence because they've got the beneficial title. State owns everything because they got the beneficial title.
So in other words, what you're saying is that we need to be extremely careful with whatever documents we submit into the county, mostly for the fact that we're trying to train ourselves to be the true creditors and get out of creating or accruing more debt for not just ourselves but for the country itself. So in other words, we need to be extremely careful with how we do that. Otherwise, if you were to be on the debtor-creditor side using 9091s and 28s, or using some of the language that, like the allodialship and land patents that exempts those kind of properties and use it that way, what you're saying is that we will be working and understanding how to go back in there under trust law and successfully 100% or at least close to that, be able to free ourselves from that beneficiary right that the county has claimed.
Yeah, absolutely. Yeah, once we learn how to administer the trust and not commingle and breach our own trust. If we cut these bonds loose that is attached to the property by taking the property out of the county, and we create these free-floating bonds, they have to attach them back to something. They're going to attach them back to a bond, and that bond is probably going to mean your arrest. So you need to come up with a substitute for what you took out of there, or go back in and extinguish or terminate all those other bonds that are connected to that property.
And do you have like just a tentative right now, right off the cuff? You got like an idea that you can just state? Would it be similar to what we're doing with the merging of the titles, or would it be more extensive to, like, say, for instance,
some kind of negotiable debt instrument is going to take the place of that negotiable debt instrument deed. So I'm going to come in there with, say, 2 payment instruments, 2 money orders, or maybe 2 special deposits under trust now. I could probably maybe do it that way. And make the payments of all known debts against that property and all unknown debts or obligations against that property. So 2 payment instruments. One paying everything I know of, and another one paying everything that I don't know of. So the one that I don't know about is like a blank check, and that will take care of all those obligations.
Would you say that the birth certificate would be our best trust res in order to execute both of those different things, or are you looking at the possibility of some other type of trust res that would most certainly be the most effective way of going about this?
Just another special deposit. My signature. That's my equitable asset.
All right, but would that be drafted off of, would you be putting that, and I'm not trying to say debtor-creditor drafting off the U.S. Treasury, but would you initiate,
It's money order that we used to start out with, but we switched it to now, it's no longer called money order, it's special deposit order.
Okay.
So it's that would not be a negotiable instrument. That would be a non-negotiable instrument.
But would it still be a draft off of the private side of your birth certificate or the trust account that's setting up there? I mean, would that be the mentality that you're working from?
Yeah, that's from the equitable side on the trust, yes.
Okay, so if I've got it right and I understand you correctly, we would be doing a special deposit based off of the old information that we've had of doing a money order, and that would still be drafting off the private side of your birth certificate and your trust account that's sitting with the U.S. Treasury.
Right. It's not really the birth certificate, it's the account. It's the private account.
Yes, yeah, oh, well, excuse me. I mean, I'm still trying to learn all this language, but at least I got it, okay. And so what you're saying is that 2 need to be issued, one for the known debt, and the second would be for all of the unknown debt. Now, would we be serving this with like an IMY or BEN, or would we be serving this with maybe an affidavit of surety with the Form 28? Is there anything that substantiates and backs us up with the bankruptcy that delivers this and makes sure that it's getting done?
Well, it's actually the special deposit order. It's an order.
Okay. All right. And is there like an accommodating letter of the will of the grantor to shift out the beneficiary that goes along with that, or is that a separate issue?
Yeah, some instructions.
Okay, so, but does that accommodate the money orders, or is that a separate issue?
Well, kind of like what we're doing with the CC template. There's an instruction and an order. So the instruction part would be what you need to be doing, and then it would be followed by the special deposit order, which would be that non-negotiable instrument.
Okay, that's why Eric was asking me that today. He was asking me, were you thinking about putting the definitions of maxims of the law with the document or as an attachment? Well, I kind of figured it was going to be an attachment, but maybe he might have been challenging me to think about it. So I can see something here. All right. All right. The other thing is that what is your experience with this word escheator?
The Lord is in by his cheat. That's out of Lewin's Law and Trust.
I'm fascinated with this word. It came about by that the trust manual out of the FDIC tonight. This escheator pretty much defined the duties and obligations of a bank trustee in relation to the FDIC, and escheator came out very clearly as part of one of the definitions that they're not to mishandle or misappropriate any of the funds in these accounts, and it's clear that because they're going back and collecting funds through the FDIC as the federal insurance on these accounts, and they're also getting federal disbursement under the TARP, that we've got them for trouble conspiracies to extort cash out of the American public.
So are they redefined as cheat there in the document?
What it's saying is that these funds, even though they have not been claimed, I mean, what I'm reading from this, and I posted it out to everybody, what it's saying is that the banks have to be, with or without the consent of the people, they're under certain particular governed rules and regulations under the FDIC, of which one of them is that if they set up these accounts that we're going after, and they fail by breaching and taking those funds and using them for any other purpose other than turning them back over to the state to put into the, what are they calling it? It's called the unclaimed accounts of the state. By them taking those funds is embezzlement, and by them doing that is a breach of the FDIC laws, inevitably is a breach of the Bankruptcy Act of 1933, that they are not to touch these funds and personalize and take these funds and put them in their own pocket. This is what this is saying here.
Well, the definition of this cheat in Black's Law 8 is a reversion of land ownership back to the Lord when the immediate tenant dies without heirs.
Okay.
Lord was in by his cheat. He cheated.
Yeah. Now, what I wanted to read you was so important. Let's see if I can locate this real quick. Okay.
It says also down below, it says, all his cheats are declared to be strictly feudal. So you don't think we're operating in feudal times?
Oh, I certainly believe that. I can't locate it exactly at this moment because there's quite a bit of it here, but as it was reading out, under the manual that was issued by the FDIC for banks to follow, that is that they have exact detailed duties and obligations that by them not properly passing these funds that are unclaimed back onto the state or the federal government for disbursement at some future date when somebody puts a claim in on it, they could be construed as doing embezzlement and fraud and misappropriation of these particular items. Therefore, I see that this is exactly some of the detailed information that we need to add into our documents that puts them on a spot that they have no other choice. They are not a vested interest of a party of interest to these funds that the state really inevitably is. Therefore, they're defrauding either the state and or the United States both by embezzling these funds, and inevitably they have to pay taxations on these, and they're not claiming taxations, which what they're doing is they're putting these into municipal, you should read the stuff I read today, they're putting into municipal funds of which are untaxable, unreportable, therefore they are robbing the IRS, which is tax evasion, on top of everything else they're doing with these funds.
Yeah,
you remember I was telling you that I wanted to put the FinCEN 101 and the 104 along with the 3949A in these packages on the notification that they were in dishonor? Well, I was right. This stuff just popped up like God just gave it to me, and I'm reading this stuff out, and it's just blown me away.
But, you know, we could put them in a whole lot more world of hurt by extinguishing the debt. Now they don't have any money.
Well, not only that, but, you know, if they caught wind, or if you put a blank copy of the 15 and 25 from the SEC in there, that makes it mandate that the person that is a grantor of those securities was not notified, and these are fraudulent documents, and you had those things pulled off the open market, they're going to be in a noncompliance issue with the SEC on top of the FinCEN. And the U.S., you've got them left and right. If they do not follow our instructions, the enforcement power is just what I just been saying.
Yeah, on the public side, yeah.
And including the comptroller and this, you know, this one thing about the, how do you say that? Is that escheatment?
Yeah, escheatment, right.
Well, they certainly picked the right word, didn't they?
They're not hiding anything. They hide it right in front of our face.
Yeah, I mean, they're cheating you. In other words, hey, you guys, listen to what we're saying here. We're going to get out of everything your land and personal property. This is an escheatment of lands. This document I'm looking at right now, and there's no bars held. They're spelling it out, exactly how they're going to take everything away from you.
They can only do that when people are sleeping.
Well, this is true, and one of the few things that the ambassadors are going to have to, take responsibility for is we're all being trained to pick and choose the most potential people to train so they can train other people. So those things are coming on to the ambassadors that are in training right now. It won't be very much longer before there's going to be quite an onslaught of people that are going to be wanting to get in on this.
Yeah, so we have to educate everybody enough so where they gain the age of majority so they can make the choice and they can gain the power, because the power is the ability to make the choice. And when you can make the right choices as general versus special deposit, then you've reached the age of majority.
Do you think that one way we can educate the newcomers or the most potential capable ones that will really actually get it, do you think if we were to set up some form of instructions and guidelines of considerations that would refer to the documents and the CJS and the Gilberts and stuff like that, of where if we were to itemize every stage and step for them to do a fast track to get educated with this stuff, do you think that that might really help the inner structure of the new people coming in?
Well, that's what I'm going to do, spend more time with the trust ambassadors to get them more up to speed so they can teach the others.
Yeah, I get that, and in fact, Eric called me up and I gave him the download of that. Going back to the pro side of how a person can protect their property, are you leaning towards land patents, land trust, homesteads as protection elements that would offset any kind of like an unlawful detainer because you proved that you are a landowner and not just a renter? How would you wager like a formula or a pattern that people can follow to not just be a defendant, but to actually start becoming active about doing pro-constructive things in their lives to protect their properties. Would you think that what I just got done saying is the proper way for them to do that?
Well, as long as we've got a trust situation here, we're going to have to learn how to use trust. So I would put, I would think everybody should have some kind of asset protection device being a trust until they terminate the whole trust. And then I think from that point on, you have to start operating differently. And, we'll still kind of learn along the way as we go here on some of this stuff.
Now, I had a chance to talk to Keith the other day, and I was kind of telling him a little bit of my own putting this stuff together. And he says, well, Chris, he says, if you got a land patent, you can't put a land patent into a trust.
Yeah,
and so it struck me, okay, thank you for, sharing that. It really did set me to realize that you can put it into a private express trust.
Yes,
you could put it into a private land trust, but you most certainly cannot put a living land patent into a dead statutory land trust. And that's one thing that everybody out there on the call tonight, you better adhere to that because it's exactly the right thing. You cannot put it in a dead statutory land trust.
Well, yes, you can.
Well,
because when you put it into the trust, that you no longer have a perfect title or a allodial title. That becomes split, and now you've got two titles. You put the land patent into trust and created two titles from it.
Okay.
You effectively made the land patent invisible. It hid it.
Yeah, but I think what he was poking his finger at, because he doesn't know that much about trust and what we're doing over here at this camp, he didn't understand that there's a difference between the private and a land trust on the private, separate from statutory. He was pretty much identifying it as a statutory side.
Yeah, but I don't care which side you're operating on, private or public, a trust splits titles.
And so what you're saying is a land patent can still... Well, that's right. You're right, because they did it themselves. They took land patents and they split the titles, and that's what the predicament we're in. So you're right. They did do that.
Now, we want to end the problem. We merge the titles, terminate the trust, and bring the perfect title forward again. Then you can take your last registered perfect title and add yourself onto the chain, and now you got the chain of titles updated, and you bring your perfect title forward into the present. On it.
But
without the trust, because the trust has been terminated.
One trust has it. It goes into a new trust, though.
When you merge the titles, that's going to terminate the trust. It's going to allow you to bring the perfect title forward then. And then you can add your name on to the perfect title, and then you got the chain of title all the way up to your present time.
But what type of information can you forward right now on perfect titles? I mean, this is actually the first day that I've heard perfect titles.
That's allodial title.
Allodial is a perfect title.
Yes.
Okay. Now, from what I understood, if there's a lien on property and you do a land patent or you set it up in a land trust, you have to still work off and secure that perfect title by eventually taking care of all the liens or the accusations or the alleged liens that have been placed on that. Sooner or later, you have to finish all those off to have that perfect title. Am I correct about that?
Yeah, but there's no liens against the perfect title. The perfect title is held in trust, and it's been split. Now the liens are against the legal title, which is a fiction lien.
Okay. So how do you handle that? I mean, because isn't that how they get you under the property tax crap?
Yeah, right.
Okay, so how do you handle that?
Just like we were talking about getting the county property out of the county. Merge the title, make the payments against the stuff to take care of the debts and obligations against it, with the resale, putting it into another trust, that's a little different situation. But we're talking about bringing the perfect title forward, though.
Is there a set of elements that go along with what a perfect title is? I mean, is there described exact detailed understandings of what, outside of your free man on the land and claiming land patents, is there any?
Perfect title is a whole title, a complete title.
Okay, but you do not put this perfect title in any type of public forum other than it does exist and you're doing a unique identifier to that. Is that the correct way of doing it?
Yeah, you'll split the title again.
Okay, so you mean you'll split the title if you use a unique identifier and keep it on the private?
No, if you put it back in the public, you'll split the title again.
But you got to give notification to them that it exists.
Yeah, notice, not the actual details, again, like we're doing. Yeah. Just notice.
I just wanted to clarify that, but there's a lot of people listening to this right now, and they want to know this stuff. So that's why I was asking, as long as you give a unique identifier to it, and you give public notice of the unique identifier that this does exist, that's different than having this put on public record, of which then they own.
Yeah, you're just like mirroring an image pointing to the actual details held in the private. You're reflecting it back into the private. The notice, that's all the notice does. It points to. The notice in the public points to.
Yeah. Let's see. I think that's pretty much it for the night. I know that you're probably pretty tuckered out. So I'll let you go ahead and go. I did have a couple other questions, but I can wait on those. I really wanted to work this space about them being the beneficiary and how we get over that.
Well, the beneficiary, to merge the titles, terminate that trust, and then the trust doesn't exist.
Research stuff that we've been working on, would that be kind of some of the contents that we could add as our language to change out the beneficiary on that? I mean, or is it a completely different language dealing with the county on that issue?
It might be a little bit different stuff on that. You might have to hold the payments, for the knowable obligations and unknowable. So the instructions are going to be different.
It might be a good thing for us to, at some point, maybe have a private conference with Walter Buren. He's an expert on the CAFR accounts, and if you know as well as I do, birth certificates and property claims by the county are what the CAFR accounts, and there's probably more things, but those are the two main things within the county that they use as their CAFR principles for placing bonds on that. And
yeah, the funds are probably the bonds held in a trust separate, drawn against the property, the trust that's holding your property in the county.
Yeah. In other words, what they're doing is the same thing the United States is doing. They're holding the Republic as a prisoner in a jail sentence, and as long as they keep the debt rolling, is that it just buries us one more day, one more month, one more year in the hole, being incarcerated by whoever has deemed that this is the right way of doing it. Am I correct or wrong on that?
Yeah. We're compounding debt all the time, and we need to start getting rid of that debt by merging the trust and get rid of extinguishing it.
And are you still pretty much sold on the idea that we can get the Republic back just by doing the merging of the titles at a higher level than where we're at right now?
Yes.
Like IMF or, with the United States of America?
Yes.
Good. I like that. Okay. That's good and solid. That's been the same thing that you said 7 months ago, so that's good for me. All right. So I bid you good evening, and thank you for everything. We all love you so much, and we see your hard work. It's really paying off. We've got tremendous amounts of people coming to our forum. It's unbelievable, but I knew that this time was going to come, and it's going to become massive at some point. So the ambassadors need a wake-up call because it's going to get a lot of attention from here on out. So,
yeah. Well, I'm going to add a couple new ambassadors. So,
what's that again?
I'm going to add a couple new ambassadors.
Oh, great! I thought I heard wind of that, and like I said, we did a presentation here in California this morning. Eric assisted me with that, and we really turned some ears and heads on this today, and so we're trying to start getting it up and running here in the northern part of California.
Okay. All right.
All right. Well, have a good evening.
Okay. Thank you, Chris. All right. Well, thank you all for joining me, and this is let's see, this is Tuesday's call. So see you tomorrow at 8 p.m. on the talk-to number.